Well, this is these are the minutes. That's the agenda, but should we do an approval?
Yeah, we probably should approve the agenda in the minutes. Well, let's do that. We got limited time with Eric, so I'm going to just skip ahead to the predatory offender registration working group. So Eric, you said you're having trouble with audio. Now he's gone. Okay. Well, maybe we'll do the agenda in minutes. All right. So you have in your materials the minutes from the October 10th meeting. Has everyone had a chance to review the minutes? All right. Is there any objection to the minutes as they've been prepared? All right. If there's no objection, I will consider the minutes to be approved by unanimous consent. Is there any objection? All right, the minutes are approved by unanimous consent. Now we have the agenda for today's meeting. Mark, you wanted to, there might be some changes to agenda items, agenda item 3 and possibly an addition from Mark. Is that right, Mark? You're on mute, I think.
Deal with Apple.
Yeah, I've lost you here.
We got you.
Can you hear us?
Can you hear us, Mark? You cannot hear us.
There you go.
Okay.
Okay, can you hear me now? Is that?
Yeah, we can hear you.
Sorry about that. I lost my screen for a second and couldn't see you. I'm happy to have Adam give his report at any time that works for the committee.
Okay. All right. So, and what would that report be on?
We circulated this. It's a report on certain other states with a focus on neighboring states and their history with mandatory minimums relating to firearms.
Okay. So we will put that right between item 3 and 4. If that works for you, Mark.
Sure.
Okay. All right. So with that addition, is there any objection to the agenda? All right. Hearing none, I'll consider the agenda to be adopted by acclamation. All right. Not seeing Eric back on.
Hold on for a second. No.
I mean, he's in the chat, but I don't know if he needs to be on to be in the chat.
Can you check to see if he's
I did check the attendees. He's not on at this point, so I'm watching.
Yeah.
You've been on as a panelist.
Could we call him and put him on a speakerphone or something?
Possibly.
Do you have his number? I can just try to call him. Okay.
Hey, Nate,
Yeah.
I did get an email from Rob Stewart. He'll be on around 10 o'clock.
Okay.
651-793-2587.
Morgan, maybe if you can't join somebody.
Yeah, this is Eric.
Hi, Eric. This is Nate Wrights. We're in the task force meeting. Do you were having difficulty getting on? Is that correct?
Yeah, I got on and myself, but none of my audio. So I thought I would try to log off and log back in, but having trouble getting back in here now as well.
Okay. Well, I'm going to just ask somebody online. Ashley, can you hear Eric right now?
Yep.
Yeah,
I can.
okay. All right, Eric, we got you on a speakerphone or, just on a cell phone. So it kind of works that way. Seems like the people online can hear. So if this works for you, we'll just go right ahead.
Oh, okay. Yeah, sorry about that. There seems to be some technical difficulties. All I'll keep trying to log in here as I talk, but I appreciate you guys taking the time to have me at your meeting today. And I have a slideshow, but I can send that out after the meeting for you guys to take a look at if you would like. So my name is Eric Sagbold. I'm a staff attorney at the Minnesota Bureau of Criminal Apprehension. One of my duties is working with the investigations division, so I help a lot of the agents with legal issues that come up regarding search warrants and whatnot. One of my duties is also helping the Predatory Offender Registration Unit with the POR registry and then questions they have regarding registration and registrants and whatnot. So I wear a few different hats around here. We actually, you may have seen, if you guys keep a tab on who's hiring, we've actually just posted for a full-time attorney position to help out with the POR unit, given that it is a very labor-intensive job, taking a look at a lot of the registrants that come through the system. A lot of the work is really analyzing if a person needs to be on the registry or not. So taking a look at the police reports, the charging documents, transcripts from sentencing if necessary, working with corrections and probation, and local law enforcement as well, obviously. So a lot of stuff going on here. So I was asked to kind of give just a quick overview of the POR system here at the BCA. And so to do that, I know your focus is more on the mandatory minimum sentence portion of the registry. And so I'll kind of highlight some of that as well.
Eric, can you hold on just a second? We do have a question from one of the task force members. Ashley, you had a question?
Yeah.
Hi. I just wanted to check in now that Eric was talking a little bit more, just to make sure that everyone can hear him online. Like I feel like I can hear him, but I don't want to speak for everyone. I know there's been a couple times where my brain has cut up, but I just wanted to check in with the other folks online if you can hear Eric.
Well, Eric, you're now back online. Can you try out your audio now? Eric, can you hear me?
I saw a couple head nods, so perhaps. Can you guys still hear me?
We can hear you. Can you hear me?
All right. Looks like I maybe got into the WebEx. I can't hear you guys now, though, so it must be something with the audio.
I don't. So,
Oh, you hung up?
yeah.
Well, we can hear
Let
you.
me take my headset off, see if that helps.
We can hear you, Eric. So can you hear us? No, you cannot hear us.
Can you guys hear me now?
Don, can you put in the chat that we can hear him?
Yes.
All
And,
right. Seems like I still cannot hear you, however. So that's interesting.
all right.
So if you do have any questions, feel free to, I guess, throw it in the chat. I should be able to see the chat as well. Let me try to share my document here as well. And are you able to see the PowerPoint?
Yes.
Okay, excellent. So the history of the registration law really dates back to the abduction of Jacob Wetterling. And so, like I was saying yesterday, this presentation, I whittled it down quite a bit. I wasn't sure how much time we would have here today. Typically, this is about a 3-hour presentation. So I know we only have like 20, 30 minutes here today, so I'll kind of fly through some of this introductory material as well. But it kind of helps set the stage for why the registration was set up in the first place. So in 1989, as most of us know, Jacob Wetterling, he was abducted. There was a big manhunt to find Jacob, and eventually the perpetrator was found, Danny Heinrich. And that whole incident led to what ended up being the creation of the Minnesota Sex Offender Registry. So at the time, law enforcement officials really did not have a way to determine where sex offenders were living or to know who had committed similar crimes in the past. And then also communities didn't have insider knowledge into dangerous offenders who were living in the community amongst them. So in response, the Minnesota legislature in 1991, the Minnesota Sex Offender Registry went into effect. So the first version of the law was pretty minimal. It only applied to offenders who were sentenced to prison and released after August 1 of 91. Only applied to adult offenders with child victims, and there were only 8 offenses at the time that required registration. And the registration period at that time was 10 years. So the 8 offenses at that time were kidnapping, crim sex 1 through 4, solicitation of children to engage in sexual conduct, use of minors in a sexual performance, solicitation of children to practice prostitution. And again, very limited in scope as far as who it applied to. Since then, the legislature has amended the predatory offender statute almost every legislative session. So in the 34 years since the registry was created, there have only been 7 years where there was not an amendment. So I'll highlight just a few of those changes here, sort of more as they're applicable to this group. But again, every year there's almost a change to it, which ultimately results in a change at the BCA end and how we are able to track and determine who is actually to be on the registry. So in 1997, some of the changes were that this annual verification letter requirement was added. So the BCA would send a letter to registrants at their registered address. The registrant then needed to sign and send that back to the BCA to confirm their location, so to speak. And the BCA is required to mail those within 30 days of the anniversary date of a person's initial registration. Offenders are required to sign those within 10 days. And at the time, the first violation of the failure to register was a gross misdemeanor. And then subsequent violations were felonies. So also then any violation of the POR law subjected the offender to an additional 5-year registration period. A couple years later then, there was the incident involving Katie Poyer. Again, obviously another tragic incident where a young woman this time was kidnapped. She was found murdered. And in this case, it was Donald Blum who was investigated. And ultimately, he was brought to justice for that. So, but as far as the predatory offender registry goes, that ended up in multiple changes again to the registration law. So in August of 2000, the Katie Poyer law took effect. The name of the registry was changed from sex offender registration to predatory offender registration. And this time, this is also where then first-time failure to register violations increased from a gross misdemeanor to a felony. So again, you guys are kind of looking into the mandatory minimum for this. So it first went to a felony in 2000, so 25 years ago already is when that went into effect. Also then registration periods were increased. So before it was typically 10 years. Now it is lifetime for some offenses. It also required offenders to provide the address of other properties they owned, leased, or rent. So in the case of Donald Blum, that was one indication they could not, they did not know of the property. He had a second property that was not on his registration or law enforcement was not familiar with. So they were unable to quickly go to that address. Also, the registrants are now required to report employment, school, and vehicle information as well. And then also added was incarceration for any new offense requiring registration, restarted the 10-year registration period. So quite a few changes again after that incident. Let me open up my chat here to see if anybody had anything. Nope, all right. So moving on then, a few years later, 2003, unfortunately, there was another incident. Drew Shodine, she was kidnapped, and this was in Grand Forks, I believe. Ultimately, this resulted in a prosecution as well, but law enforcement found that they didn't lack all the information they would have liked to be able to track down and look at suspects in the case. So this resulted in additional legislative changes in 2005. So here again, a couple pertinent changes made at that time. One thing, the second entry down there, the BCA is now allowed to inactivate registrants who move to another state. So that's one way that offenders who move between states, there's also the federal registration in SORNA, but Minnesota now we're able to inactivate registrants who move to another state once we are able to determine that they actually have moved to the location they say they're going to move to in that state. Jumping way ahead, so a lot of changes between 2005 and 2023 as well. We're kind of just skipping through a lot of that. A lot of times what we see too is changes are made and then they keep changing and they keep adjusting, which does make it interesting for our analysts on our end, because when we do get old cases, we need to look at the law that was in effect at the time and whatnot. So these changes always keep compounding the difficulty of determining whether a person needs to register or not. So in 2024, there are a lot of changes again. One of the big ones was false imprisonment convictions were no longer registrable offenses. This is not retroactive, however, so that again has created some opportunities, I guess, should we say, for analyzing whether a false imprisonment results in registration or not. 10-year restart period no longer applies to all offenses. So now it only applies to offenses that require registration, which I think makes sense because in the past, if a registrant were to get a DWI and was incarcerated for the DWI, their 10-year registration period would restart because of that DWI. Now, however, and again, effective January 1 of 2024, they need to be incarcerated for a registerable offense for the registration period to restart. Couple other changes here. Nothing, I guess, real relevant to this group, so I'll just kind of skip through this one. Again, just kind of this exhibits or shows how every year offenses come and go from being registerable or the underlying offense itself is amended and as far as its language goes, so that changes registration. So the first bullet point here, for example, possessing or disseminating a pornographic work becomes a registerable offense. Every year it's very important for our team to take a look at what changes are being made so that we can update our policies and procedures to make sure that analysts are analyzing these correctly. So today, here, after 34 years of expansion and refinement, now we have a very complicated, nicely put, I guess, highly structured and comprehensive system for registration. And really the goal of the registry remains the same as it did back when it was first established, that it emphasizes public safety through reporting, verification, and then enforcement mechanisms for non-compliance. The statutory framework for the, I'm sorry, I see somebody did throw a note here. Could you explain the origins for the mandatory minimum? Yeah, yesterday, Nate, when we talked on the phone briefly yesterday afternoon, the origins I am unsure of. Those came about in 2000, and I don't know the legislative history that really led to that specifically for the mandatory minimums. Again, it was all those changes in 2000 came about because of the the abduction and murder of the juvenile. So I think the reasons being is that it put a little more teeth in the statutes as far as compelling law enforcement to make sure people are actually located at the address they claim they're located at. Can you comment on what a typical POR violation looks like and how it is determined which are prosecuted? So Nate, again, we kind of briefly touched on that, but for the group, typically, I think I have a slide on this later about the typical POR violation. A lot of times it's going to be because a registrant does not return their verification form that's mailed to them every year. And then what happens in those cases typically is the letter goes out to the registrant's address. We don't get a response back within the time frame. A second letter sometimes may be sent, and if there's not a response still, sometimes law enforcement will have connected with us about that incident, or will reach out to law enforcement and say, this person has not responded or sent back their verification letter. Can you go do a check at this address and see if they're there? Remind the person to fill out the form and send it back. So a lot of the violations end up from that type of scenario. As far as prosecution, the BCA is not involved at all in prosecution. Our goal is simply maintaining the registry, and our ultimate goal is really just compliance. We want everybody who is ordered to register to be in compliance with the registry requirements. As far as prosecutions goes, that's really up to local law enforcement, whether they want to pursue and write a report for a failure to register, and then ultimately up to the county attorney's office, whether they want to pursue charges and follow through on that. The BCA, we really just act in an assist capacity in those situations. Law enforcement or prosecutors will reach out to us for documentation to establish the underlying conviction, just to prove up their case that their registration was required. And then it's ultimately up to them to determine how to move forward with that case. And Dale, can you speak to the problems raised by individuals who are required to register but do not have stable housing address? So yep, there's a section in the statute that talks specifically about people who are unhoused or homeless. There's a whole separate section in there on their duties. What it boils down to is that on a weekly basis, they need to go into the police station that is closest to where they are, living, be it in a park or wherever they may be housed or sleeping on somebody's couch, whatever the situation is, whatever the local law enforcement offices, on a weekly basis, they are to go in and do a check-in on a weekly basis to physically present themselves to the local police department, do their weekly check-in, and then the police department will help them fill out the verification form and get that submitted to the BCA. And then Nate, does anyone have data on whether registration compliance improved after mandatory minimum took effect? I can check on that for you, Nate. I know we talked again briefly on that yesterday. I'm not aware of that. I did take a look at the 2022 report the task force put together, and I can't recall if there was something in there about whether compliance improved after the mandatory minimum took effect or not, but that's something I can look into. See if we have that data available. So for the statutory framework for the BCA, so really it's three main statutes that drive the registry. So there's 243.166, that's the main registration statute. It's over 7,000 words long. It's got like 9 primary subdivisions, but each of those have multiple parts. Over the years, it's become sort of a patchwork of the various legislative amendments over the last 34 years. What would be nice is if someone were to take on the effort of rewriting the statute to make it more clear. I know the political climate right now probably isn't the greatest to take that on. Nobody really wants to get involved in a complete rework of the statute, but it has become very complex and hard to decipher. And then with all the changes over the years as well, determining what law was in effect at the time the person was convicted or released from custody becomes more difficult as the years go on. The secondary statute is 243.167. That's the registration for crimes against the person offenses or CAP offenses. So these are additional offenses that can require registration for other offenses. And then the final one there, 299C.093, that's the 299C is the chapter that governs the Bureau of Criminal Apprehension. So the BCA under that particular statute has been given the duty to maintain the registry. So that's really where our statutory authority comes from. And like I said earlier, our main goal is just compliance with the statute following 243.166.167. And we don't get involved at all in prosecutions or discretion as far as who to charge, who not to charge, and whatnot. So who is required to register? So a lot of this stuff is available on the BCA website as well. There's a whole section for predatory offender registry. And we have created a chart. The DPS just upgraded its website a few months ago, and so now this exact chart doesn't show up. It shows up more in a web format. But for the most part, it provides information on who is required to register. So it sets out all the offenses that require registration. And what we internally call this is the list 1 offenses. So these are the primary 0.166 list 1 offenses. And you'll see over in the far right column, some of these have some disclaimers. This is not a complete, we have a whole manual that talks about all of the various differences between the statutes. But for example, crim sex in the 5th degree, about the 8th line down there. So it's subdivision 3 only prior to July 1 of 2023, 3 sub B only after a particular date. So you can see just kind of from these few entries here how the dates are very important as far as when the offense occurred and what law was in effect at the time of the offense. Here's a continuation of the list 1 offenses. Crimes against the person. So these are a little different. So they capture additional crimes as well. These need to be, if it's an out-of-state, it needs to be comparable to a Minnesota registrable offense as well. These crimes are a little more broad, so it includes firearm possession, some assault crimes, and you'll see there as well, there's sort of a formula that needs to be applied to determine whether a CAP offense requires registration. So if there's a prior conviction from a list 1 offense plus the new list 2 or the CAP offense, then it's required to register. And so again, a little complicated as far as determining who needs to register under the CAP offense statute. And here's a continuation of that list. You can see that has quite a few offenses there as well. And these offenses, they are apt to change on a yearly basis as well. For lifetime registration, there's again kind of a complex determination of who needs to register for life. Obviously, I won't go through all this, but there are different scenarios that require a person to register for life instead of for 10 years. So that's also something that we determine internally here. I should also mention that we also consult with the Attorney General's office. Anytime there's a same set of circumstance or an out-of-state incident, we confer and consult with the Attorney General's office to have them take a look at the police report and the complaint and the charging documents and the sentencing warrant of commitment, just to have them confirm that yes, registration is required in this case. So we really work in collaboration with the AG's office in determining who needs to register. And like I was saying earlier to Nate yesterday as well, that the biggest part of the BCA's involvement in the registry is maintaining the registry, obviously, but then also determining who is required to register. And then if there's subsequent convictions, whether the registration period changes, or if it goes from 10 years to lifetime, or if 5 years is added for a failure to register conviction, or 5 years is added for non-compliance. As far as prosecutions and pursuing mandatory minimums, that's kind of, again, outside the realm of what the BCA is involved in. I think I said to Nate yesterday, really the BCA has no skin in the game on that. We assist law enforcement and prosecutors just as far as getting them the information they need for the prosecution, but we don't weigh in or have any involvement in that at the BCA. Also, Nate indicated yesterday you guys had a little interest in what information is required to be provided upon registration. So that's in subdivision 4A. And again, this has changed over the years, but as of now, it contains those 8 primary sections there, the primary address, secondary addresses, and whatnot. So some statistics. So total active registrants. As of yesterday, when I was taking a look at the numbers, there are currently over 19,000 active registrants. Of those, about close to 92% are compliant, about 8% are non-compliant, and of the 19,000, the great majority are male. So approximately 18,000 are male, only 425 or so are female, and 30 juveniles on the registry as active registrants currently. Offenders by risk levels. So risk levels are also assigned to particular offenses. So risk levels are assigned by the Department of Corrections. So DOC assigns either a risk level 1, 2, or 3. BCA has no involvement in assigning risk levels. We just, again, track it. So risk level 1, a low risk for reoffending. There's about 4,800 registrants with that risk level. And then you can see the remaining statistics there. So for not assigned or unassigned, that's typically going to be because they came on the registry before risk levels were assigned, or they have not spent time in state or federal custody, so the DOC never saw them and never assigned a risk level. So again, the great majority of offenders are actually unassigned as far as a risk level. Verification letters. So see somebody maybe has a question here. Nate, when you say compliant, non-compliant, how do you know who is compliant or non-compliant? Is it possible your figures overstate or understate non-compliance? You know, our tracking is very robust, so I don't know that our figures are going to over or understate. Non-compliant, non-compliant. Compliant means that they have been returning their annual verification letters and they've provided all the information they're required to provide. So, you know, they were convicted. Now they are required to register as a predatory offender. So the offender is to fill out a initial registration form. It's about 8 pages long. Typically, they fill that form out with their corrections officer. And if they submit that properly, it's all filled out, then they're compliant. If they don't submit it, or they don't sign it, or they leave out pertinent information and they've been given the opportunity to correct it and they don't, then they're marked non-compliant. Once they're compliant upon initial registration, then when they get the annual verification letter, if they don't return that after being given the opportunity to do so, then they can be marked non-compliant. So it's really, compliance talks about statutory compliance. Are they in compliance with their registration requirements under 0.166? So that's how it's determined. We don't look into, you know, it's not discretionary. We look at everything fairly black and white. Either they've done it or they haven't. And so we obviously will give persons a chance to rectify it. But what we've seen is that a lot of these people are habitual. You know, they've been convicted of a crime, often multiple crimes. The majority are probably not the most honest people in the world, are very trusting in law enforcement. So they habitually refuse to fill out the form when requested to do so. So I think a lot of the non-compliance is just kind of that type of personality. Ashley is asking, any data on how often failure to register coincide with causing harm to a person? Again, no, I don't have data on that. I can check and see if we track that. My feeling is we don't, because again, the BCA is just tracking typically who's on the registry, compliance and non-compliance. We're not really looking at subsequent crimes, you know, whether a failure to register causes harm to a person or not. But again, I'll look into that one. Does the BCA track the breakdown percentages of people required to register based on convictions of registrable offenses and people required to register based on the charge with the rising of the same set of circumstances? No, I do not believe we track that type of information, charged with rising of the same set of circumstances. No. Yeah, that would be interesting, but we don't track down to that granular of a level as far as that type of information. So yeah, great questions. Back to the slides, verification letters. So mentioned this a couple times. The BCA is required statutorily to send out these address verification letters, and they're meant to confirm that all the data we have is accurate and that the addresses they've listed as being primary are actually their address. Offenders have 10 days to return it, or they're marked non-compliant. For level 3 offenders who are not under supervision and civilly committed offenders, we send those letters out semi-annually. For everyone else, though, it's annually. Yearly, they get the letter to verify their address and their information. Incarceration reports. So in 2008, the legislation was passed requiring jails to notify the BCA if a registrant is admitted into a jail facility. So this, I believe, again, I don't have the legislative history from 2008, but I believe it was intended to help people who are not registrant or not compliant to become compliant. So since 2008, we've received over 118,000 reports of registrants being booked into a jail for any reason. Doesn't need to be for a registrable offense. Of those, close to 10,000 reports related to registrants who were known to be non-compliant at the time they were booked into jail. And then of those, close to 8,400 were then made to be compliant after the report. So this has really helped being able to help registrants become compliant at the time. So, it's a pretty good percentage there between the number who were non-compliant upon admission to jail to being compliant after that incarceration report was filed. And again, kind of goes with the BCA's goal of just making people compliant with the statutory requirements. Registration procedures. So again, this is something Nate brought up yesterday in our conversation, just the 5-day notice. So there are notice requirements. Registrants are supposed to give notice if they're going to move. So it says, except as provided in subdivision 3A. So 3A is the provision on homeless offenders. So people who have a primary address at least 5 days before they start living at a new primary address, including another state, they're supposed to give notice to their corrections agent or to the law enforcement authority where they're currently registered. The person's also supposed to give written notice to the new states. If they move to another state, give notice to that new state that they're going to be moving there. So there are several notice requirements in the statute as well. I can imagine you're curious about whether we track how many people are charged for failing to give notice. Again, something we don't track. My feeling, though, is that not many people at all are charged with this. I think it's very rare that a prosecutor is going to go after somebody for not abiding by this 5-day notice provision. But again, that's just kind of my gut feeling on that. So failure to register. So like I mentioned before, in 2000, the legislature created the mandatory minimum sentence for failure to register. The purpose was to enhance law enforcement and prosecutors' ability to enforce the registration requirements. Again, BCA is not involved in charging decisions. There is a provision in the statute that gives prosecutors authority to file a motion to have a person sentenced without regard to the mandatory minimum sentence. Again, I'm not sure how often prosecutors do that, but there is a provision there that allows them to simply file a motion with the court indicating that they would like the person sentenced without regard to the mandatory minimum. And here is the statutory section. So it's subdivision 5 and 243.166. So a person who is required to register knows or reasonably should know the duty. And then there's the two primaries. So they knowingly commit an act that violates the statute, or 2, intentionally provides false information to corrections, law enforcement, or the BCA. And here there's the imprisonment for not more than 5 years or payment of fine not more than 10,000 or both. And I think in your 2022 reports, recommendation was made that B, which I highlighted in yellow, that B be deleted or removed from the statute. As of today, it's still there. So B, so a person convicted shall be committed to the custody for not less than a year and a day, nor more than 5 years. So there are the criminal penalties and the mandatory minimums for that. For non-compliant registrants, we do have a website where people who have been non-compliant for 30 days or longer, they're over the age of 16, and law enforcement has completed an 11-step checklist, they do get posted to this website. So as of, again, yesterday, there were 682 non-compliant registrants posted on the public website. So it's not all non-compliance. As we saw in an earlier slide, there's more non-compliance than that, but 682 non-compliance who are over 16 and have been non-compliant for 30 days or longer. It's just a screenshot there of the registration public website. So again, here, just to kind of reiterate, you know, the BCA, we take the position of just being neutral as far as the registry goes. You know, we've been directed by statute and by the legislature to maintain this registry. And our objective really is just compliance with the registry and compliance with the statutory law. And really that's what our goal is. You know, we do internally here, we have a supervisor who is a sworn law enforcement officer. She is the manager, supervisor. One of her duties is managing the Predatory Offender Registration Unit. It's made up of 10 analysts, or spot techs as they're called, within the state. And these are people who, 2 of them specifically focus on out-of-state offenses. The other 8 focus on Minnesota offenses for the most part, and they just break up the registrants or offenders' name by alphabet. So each of the 8 analysts has a section of the alphabet based on the offender's last name. So then they are in charge of making sure everything in the registry database is up to date and compliant, and that offenders who have a duty to register under the statute, that they are registering in compliance with the law. So it's a lot of work for them. They have a lot of cases, as you can see, you know, over 19,000 active registrants. So you know, they do a great job, and their job is tough because, you know, they're looking at these types of offenses, looking through these police reports on a daily basis, and then looking very closely at the dates and what offenses were charged, what were not charged, what were dismissed, they were convicted of. And then they also can rely on me as legal counsel when questions come up, and then also the Attorney General's office. We consult with them on this as well. So that's really it in a nutshell. You guys have had some great questions. Look like Nate maybe had one more. Yeah, sure. I can stick around here for a few more minutes. And like I said, I can email Nate. I can email you the slides just to disseminate if anybody wants to take a closer look at them. But,
all right. So if anybody has
the audio isn't working here.
So if anybody has any questions, let me know. I'll type them in the chat for Eric, or if you have, if you're on WebEx yourself, you can type in the questions.
If anybody else has any questions, throw them in there. Or if you think of something later, feel free to shoot me an email, and I'll try to answer the best I can. Some of these data questions too, like I said, I don't think we have the ability to track that, but I will check, see if our tech team has the ability to pull any of that data that you've asked about.
All right, not hearing any questions. Okay.
All right, I guess
All right.
Not seeing any questions. So thank you, everybody. I appreciate the time, and enjoy the rest of your meeting.
Thank you.
Thank you.
All right. It's almost like you heard us. Well, so just kind of tracking where we are so far, we've taken a look at 6911. We took a look at both the firearms, the felon in possession, used to call it, and the committing a listed crime while either possessing a firearm or while using a dangerous weapon other than a firearm. And now we've looked at predatory offender registration. So between those three mandatory minimums, or two, depending on whether you kind of lump the 6 and 9/11 ones together, we really looked at 90% of the, well, I should say that if you look at I think it was 2023 data, looking at who's been, potentially subject to these mandatory minimums, we've looked at about 90% of the cases, by case volume as far as how these mandatory minimums affect people. And again, it's not to say that they affect everybody equally, and the ones we've looked at have waiver provisions, so and some pretty high departure rates from these mandatory minimums. So that's not to say that that there aren't some in the 10% that actually have a greater impact. Obviously, life without the possibility of release has a pretty significant impact. No waiver, no exceptions. But the next biggest area to look at would be the drugs, the drug mandatory minimum. And then we kind of just said, I think the drugs are probably about 7%, I guess, 6 or 7. I haven't done the numbers, but we have kind of done at least some look at at about 90% of the mandatory minimums. Just to pause for a minute here on predatory offender registration, a minute more. So there was a predatory offender statutory framework working group that met a few years ago, not too long ago, and I, full disclosure, was on it. So I sort of get 2 votes if we're going to look at this issue again, because I had a vote back then as well. And that working group voted to basically eliminate, one of the 2 mandatory minimums. So that would be the first time mandatory minimum. Not necessarily eliminate the second time mandatory minimum. So you recall that any violation of the predatory offender registration statute, any intentional omission or commission that violates the predatory offender registration statute, or any lie in connection with the predatory offender registration, that is a felony now, and not just a felony, but it carries a mandatory a year and a day in jail. Again, this is a waivable mandatory minimum, but that is the stated mandatory minimum, year and a day in jail. A little inside baseball on how the sentencing guidelines work. If there's a mandatory minimum involved that would sentence somebody to prison, even if it's just for a year and a day, that's considered a prison sentence. Anything longer than a year, well, anything of a year now or longer is a prison sentence. So the way the sentencing guidelines treat that is a little odd, because they say not that the presumptive sentence is a year and a day, but actually the presumptive sentence is whatever the duration happens to be for that. Even if it was a presumed stay, let's say it's longer than that. Let's say it's 21 month stayed sentence and you get a year and a day mandatory minimum. The guideline sentence that's going to come out of that is 21 months, because that's the guidelines duration, and then a presumptive executed sentence, because that's the statutory disposition, if that makes sense. So you end up with a guideline sentence of a presumed executed 21 months, even though the statute doesn't presume 21 months and the guidelines don't presume executed, but you put them together and you end up with a presumptive 21 months. And I can say that a lot slower if you need me to. And I recognize that can be pretty confusing. So it was most of the decisions from the predatory offender registration statutory framework working group, I think I'm saying that right, were by consensus. And one of the big factors that was considered in this mandatory minimum was that it was there was a high departure rate, and so it really wasn't. The danger, I guess, of a high departure rate is that it can be applied in different ways in different jurisdictions. So maybe in some jurisdictions, and we heard Eric talk about this a little bit. It's really, there's a lot of discretion in jurisdictions on whether they want to prosecute this. I mean, if somebody does not give 5 days advance notice that they're not going to be sleeping in on Jimmy's couch, they're going to be sleeping on Billy's couch, and that's how some of these people are. I mean, their permanent address could just be somebody's couch. If they don't give 5 days advance notice of that, technically they violated the registration requirement, even if they stop by the police department on their way from Jimmy's place to Billy's place. They're technically in violation if they didn't give it in five days advance notice. Now, do we see a lot of prosecutions of that? I don't know. We didn't see prosecutions of that in Rice County where I prosecuted, but it is possible for somebody a jurisdiction to prosecute that. And moreover, it's possible for a jurisdiction to push for the mandatory minimum, whereas another jurisdiction might not push for the mandatory minimum. So anytime you see high departure rates, I guess what I'm trying to say is there's a risk of geographical disparity. There's a risk of people in one place getting one deal and people in another place getting another deal. And that was one of the concerns I think that the task force, the working group had on this particular offense, was that because there's such a high departure rate, it has the potential ill effects as far as disparities go. Having said that, the departure rate doesn't really drop off much if you look at the repeat offenses. In fact, I think depending on what time frame you're looking at, it's really about the same or even higher. So that is that a 2-year mandatory minimum for repeats? That doesn't drop off. So yeah, so it's a year and a day for the first and 2 years if you've previously been convicted. So really, any way you slice it, these mandatory minimums have a high departure rate. Although it's certainly easy to make the argument that the repeat violator is more culpable and therefore more blameworthy and worthy of the mandatory minimum. There was a minority report, as you've seen if you checked out that report that was from law enforcement, and it's I think pretty obvious why I was raising that question about data with Eric, because law enforcement's objection was, hey, we got a good thing going here. We have pretty high compliance rates with these mandatory minimum statutes. Now, I'm going to push back a little bit on what Eric said, which is, he's looking at compliance. He's looking at one metric of compliance, and that is we send out a letter and they send it back. That doesn't necessarily mean that the registrant is truly compliant, right? The registrant might have bought a new car and didn't declare it to the PO or something. I mean, there's just a lot of different ways to violate the statute, right? You've got to declare your primary residence, you got to declare your secondary residence, you got to declare your motor vehicles, you got to declare your employment. So, I mean, there's a lot of things that the person might not have declared, but still gotten the letter in the mail and turned around and sent it back. But even so, let's give them their measure of compliance. It's a pretty high measure of compliance. Eric said in the 90s, and the law enforcement position was, look, we got a good thing going here. Let's not upset things. We got a high measure of compliance. So I think that the data question is, okay, was it a lot worse before the mandatory minimum? I mean, we kind of have a natural experiment here, right? There was a mandatory minimum that was implemented, I think he said in 2000. I don't actually have the date there, but before 2000, were people much less compliant, and then all of a sudden everybody locked into place? And I don't know if 2000 was also when they bumped it up from a gross misdemeanor to a felony. So I guess it's not a perfect natural experiment because, as he said, they're always tinkering with the predatory offender registration statute. And I'll just add one other thing. The fact that the statute is terribly confusing and a bit of a mess, as Eric alluded to, is is not just a problem for lawyers, right? Because it's a requirement that the people intentionally violate the statute in order to get convicted. And if the statute's really, really hard for lawyers to understand, how much harder is it for somebody who's going through the system and maybe trying to stay compliant, but just really confused on all the requirements? How much harder is it for that person to understand? So that's, I think all I have to, all my, that's really my recap of the working groups report. And I hope you found Eric's presentation to be interesting. Any comments or discussion on predatory offender registration mandatory minimums in general? Ashley.
Yeah, I've reached out to some of our members about the mandatory minimums regarding the predatory offender registry, and I guess I just wanted to share some of the feedback that I've received. I guess kind of two things that have kind of risen up is, one is that there's a mandatory minimum for first time failure to register, but there's not a mandatory minimum for the criminal sexual conducts unless it's like second offense or a weapon or something like that. So it seems to be, I guess the way that advocates are looking at it, a little bit disjointed, that we're assigning a mandatory minimum for something that is kind of deemed like a failing to help law enforcement out versus like maybe perhaps like the victim survivor. That being said, I think a lot of advocates that I've talked to have been like, is it really that difficult for someone who's committed like this level of harm to then have to let law enforcement know where they are? And I mean, clearly we know folks have a lot going on, but just like as a way, as they just, I guess, kind of felt like it wasn't that much to ask of someone, considering the crimes that someone could be on the registry for. I'll also say that, and I'm kind of going out on a limb here because I don't actually have this data, but what I hear a lot is that someone who fails to register is more likely to have another failure to register rather than actually causing harm again. That recidivism of actually causing sexual harm is low. And so, you know, that's something that kind of sticks with me too. But I just kind of wanted to lift up some of the things that, you know, have been in discussions. And I know there's kind of opinions across the board there, but I just wanted those to be considered.
Thank you. And I'm trying to remember if that was something we looked at the working group as well, was what type of crimes are the people committing?
Yeah, and can I just, I want to like uplift and maybe everyone else gets this and I'm just emphasizing something, but what I often see as point of confusion in my work is that like failure, or that the registry is kind of, I think sometimes people can think of it as like probation. And so when they hear like, oh, failure to register, like I know we just went through this presentation, but I'm thinking like, oh, maybe someone caused harm again, and that's why like they're not following the requirements of the registration. But like really, the registry is a tool for law enforcement. So it doesn't necessarily mean someone, you know, is causing harm again. It's just that they didn't let law enforcement know where they were. And so, yeah, I think I just wanted to kind of lift that up, but that can kind of be confusing for folks. Yeah, and I wasn't on the working group, but I did attend a lot of those meetings. And thank you for your recap of that.
Sure. Any other comments?
Hey, Shane.
Shane?
Yes, in looking at, when I was reading these materials and I was jotting down questions I had, and I feel like we need to look behind what some of the basic data or some of the data on the mandatories are. Some questions I had, for example, were, do we know if departures are based on agreement of the parties, or is a judge doing it on their own? Are they occurring more in first violation situations or second or subsequent? Just in general, what are the cases where there are departures? Does someone's criminal history score affect where a judge does or does not depart? Certainly data on durational versus dispositional, since those are two different things. Dispositional is whether you go to prison or stay on probation. Durational is the time of the sentence. Certainly locations in the state. Is there any section of the state that's more greatly ignoring the mandatories or departing versus others, or is it more consistent? I raise all these questions because I think we need to dive into those things to know whether this provision makes sense. And I think it's important, at least for this particular mandatory minimum, is at least for the first violation, it's pretty soft. And what I mean by that is the guidelines themselves make it a presumptive commit. The statute provides the judge on their own motion to depart with substantial and compelling reasons, which is the same standard a judge can depart from the guidelines. So we actually have a mandatory minimum for a first-time offense that is the same punishment as what the guidelines call for. So it really is a mandatory minimum with no impact. The second one can be because the duration is higher, but still it has the escape hatch of judicial discretion in that. And this is different than some of the other mandatory minimums we'll be looking at. As far as on cases my office has dealt with, victims tend to be interested in whether someone's going to have to register. Tending to be wanting that versus even many other kinds of sanctions, but it is a thing that the attorneys in my office are discussing with victims because they certainly are interested. I know there's a lot more questions than answers, but if we're kind of looking at what's the impact of a mandatory minimum, I think these are things we need to look at.
Thank you. And I will say some of those data questions are addressed in the report. I don't know how it's marked exactly, but it's a report from the Minnesota Sentencing Guidelines that.
Oh yeah, they had these nice charts.
Yeah, it's a little
through
confusing.
2019.
Right, through 2019. So we could get more current data, certainly. But as far as, if I'm reading this right, these are numbers of cases. So there were 65.8 cases annually, I'm guessing is what that means, where there was no dispositional departure, and 79.7 where there was a dispositional departure. So most of the first-time offenders got a dispositional departure. For subsequent, it was 34.2 did not get the dispositional departure, and 20.3. So there, a majority got the mandatory minimum. The second comment I would say is I think it's a little bit of a chicken and egg issue there with why the guidelines call for a presumptive commit on that. And you know, its guidelines policy, as I previously said, that if the law provides for a mandatory minimum prison sentence, then the presumptive duration changes from stay to commit, even if the guidelines would call for a stay. So for example, second degree assault is ranked at severity level 6, which calls for a stayed sentence at lower criminal history scores. But in fact, every single second degree assault worksheet is going to say presumptive commit, even at low criminal history scores. And the reason for that is that every single second degree assault involves a dangerous weapon, and it's on the list of offenses where if a dangerous weapon is used, it must be a presumptive commit. So the guidelines basically the commission has made the choice to honor the legislature's directive to make it a presumptive commit in mandatory minimum cases. I think the most likely explanation and the most the most accurate explanation, looking at the history, is that the commission ranks all of those severity level I offenses at presumptive commit because there's only one offense listed at severity level I, and that is failure to register as a predatory offender. And since the mandatory minimum applies to every single failure to register as a predatory offender, the commission just said, well, we'll just make that whole row non-shaded because everybody's a presumptive commit in that case. So I don't think it's accurate to say that that's a choice of the commission's, other than it is true that the commission has made the choice to honor legislative decisions about presumptive commits. So the commission has chosen to honor the fact that the legislature is making these all presumptive commits, but that's not to say the commission considers them all to be worthy of prison. In fact, you could infer the opposite based on the fact that the commission has ranked that at the very bottom of the sex offender grid, and which means that every other offense on the sex offender grid is more serious, and some offenses on the sex offender grid, as Ashley pointed out, do not call for a presumptive commit for people with low criminal history scores. Dale?
Yeah, thanks. I just wanted to, this is anecdotal, but in my experience anyway, almost every predatory offender registration offense that I saw in my career was somebody who did not have stable housing. And to sort of respond to one thing that I think Ashley brought up, you know, how big of a deal is it for somebody to have to register? If you have a stable address, I don't think it is that burdensome. If you do not have a stable address, which also probably means you don't have stable transportation, and a lot of the folks that I dealt with were, for lack of a better term, street people. They're, you know, low functioning or marginally functioning. And for them to remember to go to the police station once a week, I think it sets that demographic up for a lot more criminal exposure. And so my concern anyway is that, you know, the way that the statute is structured right now, and the mandatory minimum is part of that, is it's a group of people who are struggling with a whole lot of other things in their lives. And I think that's one of the reasons why prosecutors, at least in my jurisdiction, were far more likely to agree to a departure on something like that, even if it is a subsequent offense, because they're just, you know, even in a city the size of Duluth, the cops know who most of these guys are, and they can find them if they have to, but getting them to actually comply with those weekly registration requirements is a losing effort sometimes. And eventually they get fed up with it and they get charged. But I suspect there's a whole lot of them that are never getting charged because they are, you know, trying to work with the people and realize that they just may not have the capacity to do it. But that's, I don't want to sound like a data nerd, but anytime you start looking at this stuff, there are a million questions about can we show this, can we show that? One of the things I would like to know is the percentage of the prosecutions or convictions or departures that relate to people who do not have stable housing, because I do think that that's a probably going to be a pretty significant disparity.
Yeah, and I don't know if we can get the data on that. And Rob, there's been a number of sort of implied data questions out here. I don't know if you've been tracking them, but it'd be good. And I know like some of these would just be a request to the Sentencing Guidelines Commission. I know they could work on departure. I mean, we don't have you know, whether somebody's unhoused or not. I don't know that we track that. I do believe we've been collecting, but haven't been using zip code information and other information from the criminal complaint. But I don't know whether that would give us a consistent positive data point on whether the person was actually housed or unhoused. And but if, as long as we're speaking anecdotally, I would say the same thing in Rice County. Not necessarily people who didn't have housing at all, but people who didn't have stable housing and were kind of generally marginal, you know, kind of in life altogether. And you know, like I said, just kind of going from couch to couch, and weren't you know, probably weren't doing their taxes on time either. Honestly, you know, just who knows what they're doing. Shane, did you put your hand up again? Or...
Yeah, Nate, does the sentencing guidelines track stays of adjudication?
No.
Because that sometimes can be a way around the guidelines, because that's not technically a departure.
Yeah,
It's kind of an odd creature, and that sometimes can rear its head in settlements too, where the violation is seen to be technical or not worthy of executing a sentence, and in some cases not even having a conviction.
Yeah, no, and I think that's an interesting issue when you look at the high departure rate, because we've already learned that there's sort of a lot of exit ramps prior to conviction. You know, that like this just isn't worth prosecuting or whatever. But you know, maybe you do want to put the person on probation and make sure this isn't a sign of something worse. But yeah, stay of adjudication is certainly one of those exit ramps. But no, the commission, the guidelines apply upon conviction. So it's that first sentence after conviction where the guidelines first apply. So we don't look at stays of adjudication. Rob?
Sure. Sorry again for being late. I'm at the criminology conference actually in DC right now, which is very fun. But anyway, to that point. So what I would say is, like, I have some ideas. I've been taking some notes on some of the questions and comments that people have had, and I'm also going to be going back through just some of the previous things. But in terms of this, like this thing about the address piece, I don't think that's necessarily going to be recorded directly either in the court data or in the guidelines data or any of that. But I do think there are strategies that we could use to get at some of that information. For example, we could take a random sample of some of these cases and then just look at the charging documents and code that up and get a sense of what that actually looks like. Particularly the more recent ones from 2015, which are which we don't even necessarily need the participation from the courts if they're, and then I would also just say in terms of these data questions generally, I think about this. I think we should think about this the same way that I kind of, tell students to think about their research projects, where come up with all the questions that we have, and then we can kind of winnow it out in terms of what we can figure out and how we can get data from, and so not to limit ourselves ahead of time by saying we're not sure if we can get data on this or that or whatever, because I think we can be creative, and I think there's a lot of potential here. So I think these are great questions and got me thinking a lot about different ways to kind of get at potential answers for some of these questions that maybe not be perfect, but will actually at least give us a good sense of kind of what's going on.
Yes. Great. All right. Oh, yes, John.
I just think one other thing to sort of keep in mind with failure to register is Minnesota is the only state that requires registration just based on a charge and not a conviction. In every other state, you have to be convicted of that registrable offense. And unless a court says the magic words of there is no probable cause for that registrable offense, or it does not arise out of the same set of circumstances, you can be acquitted at trial of that registrable offense and you still have to register. And so those are people, that's why that was my typo in the percentages question, not Nate, I borrowed his computer. Is that those are people who are also subject to this mandatory minimum. I mean, if you were charged with theft and a crime of violence and were acquitted of that, then you are never going to be, in the felon in possession mandatory minimum because you can't be charged with it. But if you're in that same scenario here and you have to register just based on the charge alone, then you are subject to that mandatory minimum. I think just maybe something to keep in the background about this very particular offense. So
To clarify, you do need to be convicted of something, but it doesn't have to be a registrable offense.
correct. It's just arising out of the same set of circumstances.
Nate, I got one thing to add.
Yes, Nick.
One thing I'd like to add, just to put it on people's radar, I wish I would have asked this when Eric was here, but this is just data from Bloomington. So just to keep in the back of your mind, but we have 154 registered offenders. There are offenders that have to register, and there are only 58 of those that are actually on supervision. So I think not completing that paperwork, that's rough math, 2/3, that's their only supervision they might have is completing that compliance paperwork. And unless the police department has the resources and time to check up on people, which most don't, I'm just throwing that out there. And yeah, it might be the first time, but it is for most people, the only supervision they're having.
All right. Well, it's not seeing any of the discussion on that agenda item, so I'm gonna pass the gavel over to Morgan now, give my face a break and move on to agenda item 3.
Thanks, Nate. Agenda item 3 is about a report that was issued by the New York State Judiciary Task Force entitled Recommendations for Reforms Relating to Mandatory Minimum Sentences. So we reached out to the folks in New York who created this report and asked if they would sit down with us. Nate, myself, Professor Osler were there, and it was a really great discussion. And I think we learned some good lessons from it. So the report itself was distributed. We met with Noah Mammis, who is the chief of staff for the chief judge of the highest court in New York, as well as Nicholas D'Angelo, who is an attorney at Davis Polk and who is doing pro bono work supporting the task force. And a couple of big themes that stuck out to them are some similarities between New York and Minnesota. One is New York City is obviously the major urban core of New York, and then there's a large rural part of New York. So that's similar to Minnesota, where the metro area is a large urban center, and then the rest of Minnesota is quite urban. Quite rural. So I thought there was some similarities there. They also did a lot of work with data, and so they were really digging into the data piece, and they really stressed that with us of the importance of leading with data. They were really aware of needing stakeholder input, and so they had folks from the equivalent of their county's attorneys association, folks from their public defenders. They also had a number of professors who came in and presented to them, it sounds like a pretty robust process that they went through. They gave us the name of a few professors that came and talked to them that we could, I think about inviting to talk to us. And so, I think what my recommendation would be is that people take a look at the New York report, both for the process that it describes, but also the sort of the substance of it to consider the recommendations that were just made in New York several months ago. So I don't know if there's Professor Osler or Nate, if there's any other things about that report from New York that you all wanted to highlight.
I have a comment about the report from New York, but I think I'm going to save it for my reflections section because it really got me thinking about this whole enterprise and what Minnesota is doing with mandatory minimums. So I thought it was very interesting, but I'll save that.
And then, I think this leads sort of right into the work that Professor Osler and is it Adam Gallagher did, looking at some states around Minnesota. So unless there's any sort of questions about the New York State Task Force report, we could maybe move on to a discussion with him.
Shane.
Oh, yes, Shane.
Just seeking confirmation because it seemed that way. Now, New York State doesn't have a sentencing guidelines apparatus for their felony sentencing, like Minnesota?
That's
Okay,
correct.
so-
And that was actually one of the things. That's what I was going to be talking about in my reflections. Is they spilled quite a bit of ink in their report discussing whether or not Minnesota or New York should have sentencing guidelines, and I guess I just sort of had a minor epiphany when I was reading that, like, oh, maybe that's the answer. Maybe you don't need mandatory minimums if you have sentencing guidelines. So that's what I'll be talking about in my reflections.
Thank you.
Professor Osler, do you want to take it away with the presentation?
Sure, thank you. And just is kind of a little bit of overview here. So far in looking both at the material we've gotten from New York State, because they had a state-by-state review of some laws, and what Adam Gallagher, who's about to talk, has discovered is that we see that a lot of states have lowered mandatory minimums for narcotics. And Nate, going back to what you were talking about in terms of the percentage of mandatory minimums that are actually used, here we're only at 7% for narcotics, but in a lot of these other states, they were seeing very high impact of the narcotics mandatory minimums. And so you had a bunch of states who have lowered their mandatory minimums for that, and the federal system in the First Step Act had significant adjustment to their narcotics mandatory minimums. We've seen not nearly as much action in relation to firearms. There's a couple states that have had some actions. For example, South Dakota lowered their mandatory minimum for first-time offenses for firearm possession, but raised them at the same time for subsequent offenses. Now, even though we don't have a lot of state actions to point to in the field of firearms in terms of just rejecting prior mandatory minimums through statutory action, there's a couple observations I think are important. One is that we do see a lot of states resisting increases to mandatory minimums that have been proposed, and it's been a pretty hot issue in some places, you might imagine, including Texas and North Dakota. The other is that generally our mandatory minimums for firearms are higher than our neighboring states. And with that overview, I'm going to switch seats here with Adam and allow him to present.
And before I begin here, I just want to thank you all for the opportunity for me to be able to present some of these findings, and to thank Professor Osler for the opportunity as well. And I'll try to be brief because my report is kind of meaty. It's maybe 54 pages of substance, 30 pages of appendices, and that's not even exhaustive. I could have spent hundreds more hours on this and still come up feeling like I wasn't complete. And so when we talk about Minnesota having higher firearm sentences than our neighboring states, we can even look at North Dakota, who has a presumptive 2-year minimum for a felon in possession of a firearm, or we can go to Michigan and Wisconsin, which have few to no mandatory minimums for any firearm crimes for Michigan. Wisconsin, for unlawful possession of a firearm, it's a Class G or a Class H felony, which is among their lowest classification for felony, which carries no mandatory minimum, though their felony, the use of a firearm in a felony has maybe a 2 or 3 year mandatory minimum with other enhanceable factors to that. Iowa, even for a first offense for a felon in possession of a firearm, is only a 2-year mandatory minimum, though that increases with every subsequent offense to a maximum of a 10-year mandatory minimum on the first offense. And there are other states that distinguish between violent and non-violent felony prior offenses, which Minnesota doesn't seem to make that distinguishment between violent and non-violent prior offenses. And then whether it's a violent or a non-violent prior offense can change that minimum. We've seen minimums as low as 2 years in South Dakota for a non-violent prior offense, or 3 years in Nebraska for a non-violent felony prior offense. And so I can keep rattling numbers off until I'm blue in the face.
Well, why don't you talk a little bit about North Dakota and the back and forth they've had there?
So North Dakota is particularly interesting in that they recently voted down, I think in February or March of this last year, what was being called the Truth in Sentencing Act. It was pretty heavily publicized within North Dakota. And the act itself would have increased mandatory minimums across the board, requiring offenders to serve 85% of a felony sentence before being eligible for parole, which is a de facto mandatory minimum without using the magic words, mandatory minimum. It also would have increased work requirement eligibility and would have increased certain other firearm offenses, but that was voted down in the North Dakota legislature 41 to 52, despite being heavily pushed by the Attorney General of North Dakota and the Governor of North Dakota. And there have also been reforms within North Dakota to try to make their prison system more rehabilitative, but that doesn't really factor into what we're doing here today. Just that they seem to be at an almost turning point for how they're addressing their criminal justice and their sentencing requirements. Interestingly, we're talking about data and tracking departures and things. North Dakota does track departures from their sentences. They seem to have had some success in judges adhering to their sentences, because since 2016, there have only been 3 departures from their sentencing guidelines. And 2 of those were from the same judge in the same case. And the departures have been downward from the sentences.
You talked a little bit about the debate in Texas too. I know they've had some back and forth on it.
And Texas is in a similar situation with North Dakota, only it seems to be slightly more intense. Governor Abbott and the Attorney General of Texas are consistently sponsoring legislation. More than 100 bills have been sponsored in this current legislative session to try to increase mandatory minimums from across the board. These bills tend to die in committee if they even make it to committee, and none of these bills have been successful. One of the only sentencing changes that they've made isn't so much a sentencing change, so much as they added a category for unlawful possession of a firearm in school zones in 2023 in the emergency legislative session that occurred right after the Uvalde shooting. And so that's very clearly targeted at trying to penalize carrying a firearm in a school zone after that horrific event. But otherwise, Texas seems to be steadily resisting the executive push to increase mandatory minimums for any offense, let alone firearm offenses.
Let's see if there's questions.
Yeah. If there's any questions on either my Cliff Notes now or my report generally, I'm happy to take those.
I had one, Adam. In Texas and North Dakota, where the initiatives were defeated to increase mandatory minimums, was there an underlying theme anyway of the rationale behind why they didn't go down that road? Was it a cost thing? Was it data driven in terms of the impact on public safety? How did the opponents of those mandatory minimums carry the day?
So I wasn't able to find that data in Texas.
I can speak to Texas.
And it sounds like Professor Osler will be able to speak about Texas. But in North Dakota, the debate is entirely around criminal justice and whether these mandatory minimums do promote those notions of justice. They do always talk about the expense to North Dakota in their prison system. And that's one of the reasons they're trying to reform their prison system to reduce recidivism. So that's not, it is part of the debate, but the majority of the floor debate that I was able to find, and I linked to some of it in my report, seems to be making sure that the mandatory minimums actually do promote justice, and they're trying to not penalize nonviolent crimes.
Yeah, and I moved here from Texas, so having spent 10 years there, it's interesting. There, the debate really is between fiscal conservatives and who are against building more prisons and the costs that go with that, and the people who want the harsher mandatories, like the governor, and that goes way back. Texas hit a point that Oklahoma hit more recently under Governor Perry, where they were just spending outrageous amounts of money on prison building and maintenance, and they reduced a lot of their sentences at that time, and that debate's gone on since then. And I think there's a real recognition of the fact that if they raise the mandatory minimums, and this is true in both Texas and North Dakota, there's going to be serious costs, and they're probably going to have to build additional prisons. Now, Texas, of course, is big enough that they've got a pretty huge prison system. In North Dakota, the cost of building one additional prison is significant relative to their budget. So that's an important part of the discussion.
Yeah, thank you very much for the question. Is there anything else I can answer or speak to while I'm here?
Oh, okay. Thank you.
And again, thank you very much for the opportunity. It was actually a lot of fun to work on.
Shane, did you have a question? Sorry, before we.
Oh, yeah, I did have one. Question is, on the states you determined or thought of as being either hostile or adverse to reform, what mechanisms did you see that they were using to, I guess, address public safety that are, I know one was mentioned earlier by the professor about the first isn't a presumptive mandatory, but the second has a increased one. What mechanisms are they using? Because that's certainly going to be a kind of a response as well. How do we, if we change things, how are we not addressing public safety?
So the responses that I've seen have been primarily in the form of enhancements. Iowa, Wisconsin, Michigan all have pretty robust enhancements in their sentencing guidelines, as well as just increased penalty for subsequent offenses or even judicial discretion in sentencing. Those would be, I think, the biggest mechanisms to continue to address public safety that I've seen. Unfortunately, without going deeper into legislative intent than I had the time to do over these past 12 weeks, the only legislative intent that was truly clear was Washington State, because they put it in their bills on their website, which is wonderful. More states should do that. But the legislative intent in North Dakota came out through the debate on the floor that I posted to, where they're just trying to make sure that there aren't disparities in justice. But everywhere else where there are enhancements or increased penalties in their sentencing guidelines, I'm not really sure how to end that thought. I think it's just about enhancements and increased penalties depending on circumstance. Did that answer your question?
Yeah.
And Kelly?
I feel like I have to call an audible here that thank you for the work, Adam, that like your summary is really good, but I think we have to be really careful about distinguishing between sentencing schemes, because sentencing guidelines are much more prescriptive than sentencing schemes that the legislature
Mm.
might include in statute. So in some of these places, like North Dakota does not have sentencing guidelines, but they do, because they have parole. So they have a sentencing scheme that gives the court direction on the minimum term and gives the parole board direction on the minimum term that a person has to serve before they can be considered for release, which is different than saying this is your mandatory minimum. So in some of these states where like really it depends on the type of scheme that we are talking about, what that mandatory minimum does. So sometimes it will be the legislature saying, I don't care what the parole board does or the court does or whoever, but we're saying this person has to serve at least this much time, regardless of what the rest of the sentence might say. Here, with our sentencing guidelines, a mandatory minimum essentially overrides the sentencing guidelines. The commission has an idea of what the sentence should be and ranks it accordingly, but the mandatory minimum overrides that, makes it presumptive prison, may make it a presumptive length or not. Usually we conform with that length or do something to bring it in line with legislative intent. So we really have to be careful about how we're talking about these things. And it's hard to make, the long and the short of it is, it's hard to make comparisons to other states that have different sentencing schemes in some cases. So it's really, I think it's useful though to hear from these other states to understand where legislatures have put their attention, because when the legislature acts, it does override judicial discretion in some way, in some form within that state. It may not be the same way everywhere, but it does indicate legislative intention to direct the courts in a certain direction. And so it is useful to understand all that. And I really do appreciate the information that we've gotten so that we can see what other states are thinking about and what offenses are rising to the level of the legislature's attention so that they feel like they need to act because they're not seeing the results that they want to see. I would say too, Morgan, I don't know if this group has gotten the New York report, and I had to leave shortly, so you may have mentioned that or not, but I got it because I know I was in the loop to connect you with those folks, but I don't think everybody else has it. So I just want to make sure that we get that out to everybody as well.
Thank you, Kelly. Yeah, we'll make sure we get that New York report out to everybody. Great discussion so far. Any other comments or questions for Mark or Adam?
Nope. I think, first of all, Kelly, thanks for that. And it's certainly true that context matters when you're looking at one of the things that I charged Adam with was looking generally at trends. In other words, as we start this process, we want to know, is this something that across the nation, there's a bunch of states that are reforming their mandatory minimums on firearms? And the answer is no. But the bigger picture also includes that there's places that mandatory minimum enhancements, the more mandatory minimums are being pitched and being rejected.
And that is really helpful information. I mean, thank you so much for having that work done, because that is extremely helpful to us as well. I appreciate it.
Our pleasure.
Okay, great. So I think we'll move on to agenda item 4, which is reflections. What have we learned? What stands out? And what do we still need to know? Open topic for all members. I've got some thoughts. I know Nate said he did too, but if people want to jump in, who wants to go first?
I'd have to call him.
Well,
Held up here.
Yeah. Okay. Thanks, John. Appreciate that.
I think one thing that stands out, and I mentioned it, I think at our last meeting when we were talking about 60911, is that 60911 and also the predatory offender statute both have a lot of flavor in the legislature of just saying, and also, without sort of reviewing the whole thing and going back. I don't know what has really changed in predatory offender other than, say, false imprisonment being taken off. But there's just a lot of addition without necessarily thought, which is, I think, part of the reason why we're here. But I mean, just when you look through the history and just see the continual and this and this and this is something that I think we're sort of needing to comb through. So,
yeah. I can go with my reflection. And I guess it's all around a theme of like discretion, because when you think about the way these cases get processed, police have lots of discretion about what they investigate, where they put their resources, and then what they present to prosecutors. And so I think you see that both in predatory offender cases and in gun cases, where police make a decision about, for a predatory offender, if they're going to submit that to a prosecutor for consideration. I think you see that in gun cases as well. And then prosecutors have an incredible amount of discretion. Prosecutors get to decide what is the charge that we're going to bring. Are we going to bring a charge at all? Does the case have prosecutorial merit? I think you would see that a lot in the predatory offender cases. I think you would see that in some of the gun cases as well. And then you get to the sort of the last step in the process, the judges. And I think the mandatory minimums, I think a lot of times when you think about judges, you think about people who have been selected by the people of Minnesota to exercise discretion in these cases to make the sentencing decisions. But in the area of mandatory minimums, you're actually taking that discretion, I think, away from the judges in a lot of important respects. I think especially in the double mandatory, the mando cases with the gun, that's a real removal of discretion from judges. I think when you're in court in those cases, I think judges often express frustration with the fact that they are forced to impose these sentences sometimes. And so I think it's an interesting structure that we have where there's so much sort of discretion along the way, and then you get to the end where it's a person who you would anticipate having the most discretion in getting to make these decisions, and then that discretion is taken away. So that's sort of a thought that's been percolating in my mind.
can I piggyback off
Yeah.
that too? Is that there's one group who doesn't get a say, and that's the defendant.
Yeah.
Because these statutes all started with the prosecutor can make a motion to sentence without regard. And I think the Supreme Court in one of the early cases said that violates separation of powers. So they amended the statute to say prosecutor or the court on its own motion. But the defendant is never actually allowed to bring a motion in these cases. And I had at least one case where a defendant made a motion and someone said you can't. And so they wrote a letter to the judge saying, you can make a motion. And the judge ultimately granted the departure and said, I will grant the motion. And the Court of Appeals said, you granted the defendant's motion and you can't. And so, if anything, just adding something to say, hey, the other person involved in the process could also make that motion.
Yeah,
So.
for sure. Mark, you had a reflection?
Yeah, just real quickly. I wonder a little bit. We've gotten deep into some of these issues pretty quickly, and I wonder if at some point we might have a discussion of one of the really big issues with mandatory minimums, which is that it's really studying these different systems and coming from another system, from the federal system. One of the really awkward things in Minnesota is mandatories and mandatories. Just explaining that to my students, they're incredulous for a while, and we have to, practitioners, we're all used to it. But I think that big question of, do we need mandatories that aren't really mandatory is something we probably should think about at some point.
And if I could just piggyback off that real quickly, I think it's also a messaging thing for the public, right? Because then are we giving a false impression to people in the public about, okay, this thing's the mandatory, but it's not really a mandatory, and so I think it is kind of a, I think there's an overall effect that this has on people's faith or the credibility of the system generally when these, with these kinds of like bait and switch kind of, or maybe not bait and switch, but different labels that were made to these things that maybe aren't exactly what people, how they would interpret them.
We had Ashley and then Dale.
Yeah, as a reflection, thinking about mandatory minimums as they apply to gun cases, knowing that, most sexual violence is committed by people that we know and oftentimes that we love, and it's oftentimes happening in homes. And we know that, guns in homes creates a whole slew of other issues. I'm wanting to kind of talk to advocates more about this specifically. I'm also, wondering, like, what do groups that study gun violence and gun violence prevention, like if they have thoughts on mandatory minimums as well, like Everytown or I think Gabby Giffords also has a group, and I know that there is a group in Minnesota also that is an advocacy group that might also have research or thoughts on the effectiveness of mandatory minimums in reducing gun violence. So I guess I am interested in kind of learning from those experts too. Yeah.
Go ahead, Dale.
I was just going to say that, one, I'm sorry that I missed the discussion on 60911, since I wasn't appointed to the task force yet. That would have been a good one for me to be at. But when we're talking about departures, keep in mind that the bench does not have unfettered discretion. And I know that some judges take that responsibility more seriously than others. I'm a realist that way. But we have to find substantial and compelling reasons to depart from the guidelines. And we're supposed to say those on the record. Later in my career, I was not shy about asking prosecutors or defense attorneys to tell me what they thought the substantial and compelling reasons are, because we have to put that in writing, even though it's an abbreviated form, and we're supposed to put it on the record. So I don't know that there are always similar requirements for law enforcement or prosecutors to say why they're not charging or why they're not forwarding something on. But when it does get into the benches arena, we have to be able to justify a departure. We just can't say it seems like the right thing to do, I'm going to do it.
Yeah, good point. Amber?
Yeah, just to piggyback on the discretion discussion, I mean, one thing that it also creates is that the discretion of the prosecutor is extremely powerful in mandatory cases, because they can either agree that they think that a mandatory departure is appropriate or not. And whether or not it's agreeable between the parties goes a long way as to whether or not a judge will grant it. So there is the discretion of the prosecutor that can be applied in a lot of different ways, and it could just have to do with who your prosecutor is. And I know that works with a lot of other cases, but it does, I think, affect the defendant's view on, is this process fair? This is, I know I'm subject to a mandatory, but everyone I know didn't get subject to this the first time or something like that. And so I think there's a lot of power with that discretion, and maybe that's something to think about as well.
Other reflections? Mark, you still have your hand up, but
Sorry about that.
Shane, you just came off mute. Did you want to go ahead, Shane?
Oh, yeah, I was just waiting my turn. I guess I wrote down three here. One I kind of touched on before is why are the departures occurring? I think we do need to dig in more than just, hey, this crime has a high departure rate, therefore there must be hostility toward the mandatory. Because I think what I've noticed more, and that's kind of the bigger general reflection, is what the crime punishes or affects determines kind of how we go forward, what we think is fair, what we think is addressing public safety. I'll just use one example. The felon in possession of a firearm, within that, for crimes of violence that triggers our mandatory minimum, is any drug offense, which also includes any 5th degree drug possession charge. And there is no time limit on that. Our office actually saw a case where the possession was from 1989. And that was one where I was not going to push for the mandatory. You know, that's way different than if it's a violent acts against a person. You know, so you see these things. We had that big conversation on the predatory offender. Well, is it a 5-day limit? Is it, or the reporting? Is it, they're just not saying wherever they lived? Is it based on you got convicted of a circumstances connected to crime, not the main ones, or a major forcible rape? I mean, so that kind of colors whether the mandatories are fair. Unfortunately, mandatories use a one-size-fits-all approach. And then just, again, highlighting on discretion, I think it's also important to remember that the DOC has discretion here too, and that they're not the ones usually thought of. With, well, now with MRRA, with reducing the standard sentence potentially from 6 2/3 to 1/2, and that can include, you know, very violent crimes because they're still eligible, and programs like Challenge Incarceration Program, boot camp. Because I had a case where it was a felon in possession charge and that individual qualified. So they're not automatically excluded. So something to keep in mind if we're concerned about judges being deprived of discretion.
Kelly, yeah.
Yeah, so Shane stole some of my thunder because I was going to say some of the things that
Sorry.
he said too. You know, for those of you who are new to the commission, one thing I didn't say in my introduction is that I'm the chair of the Sentencing Guidelines Commission. So I have a little bit of more knowledge on that front than the average person. But the what I was going to say is, you know, that for us as commission members, when we see high departure rates, it serves as a signal from the system that there is something wrong. It doesn't necessarily mean, as Shane said, it doesn't mean the mandatory is wrong, but it means something's wrong. And I think for me personally, when I look at these places where these high departure rates occur, it's usually because, I think it's usually because the statute is overbroad in how it's trying to apply this sentence. So, you know, the statute, the definition of a crime may include a wide range of behavior, and it's hard to pinpoint what the right sentence is for that within that wide range of behavior. There a lot of offenses could be pulled into the mix that maybe don't always fit the scheme or that the legislature may have been thinking of when they enacted the law. So I think that overbroadness is one of the major themes, and I think that's what we have also heard a lot about in this context here. Like as we bring up these issues, I think a lot of times it's just because, you know, every offense under the sun has been brought into the mix. So, you know, it makes me want to think about refining these laws. Like, are there ways to narrow in where it really makes sense? If we're going to keep a mandatory minimum, is it in a lesser set of circumstances where it would make better sense to keep it? I also think we haven't looked at effectiveness of the laws. And I know on the social science side of the world, there is research that does look at like, are registration laws effective in deterring future criminal conduct? I think we should be looking at that as well and get to that root of the question that Professor Osler was asking, which is, what is the purpose of the mandatory minimum? And are these mandatory minimums that we have meeting that purpose? I don't know if we can definitively get the information in front of the task force that will make us all feel like there's a clear answer on that front, but I think we should at least consider what information might be available to think about that process and think about where we land on that.
Yeah. Nick, did you have something too?
Yeah, I'd just like to say I think I might be the only one here that doesn't have a pretty extensive law background, and so I feel like I'm playing a lot of catch up in a lot of what you guys are talking about. You know, working on the front end of these cases when we arrest somebody, and you know they're a felon in possession case where you hear there's a mandatory minimum. To be honest with you, most cops probably assume that's what happens, and the departure thing is not necessarily on our radar. So a lot of this I feel like I'm playing catch up on to try to grasp everything, but yeah, so I think that's kind of where I'm at right now.
Cool. Thanks. Amber?
Yeah, one thing we have talked a lot about is, and kind of in addition to what was just said, is I think there is a calculation that's being made by all parties. The defense is making their argument as to why a departure would be appropriate. The prosecutor is also considering that, and the judge. And we have talked about how, well, should we look at how, for instance, 60911, what the crime is, and then in a felon in possession, how is the gun just possessed? Is it used? Is it that sort of thing? I think those calculations are taking place individually in cases, but perhaps it is worth thinking about having some parameters or more limiting information of when exactly, under what circumstances, the mandatory minimum actually comes into play, or if there's certain things that could be excluded from it. Because I do think it has become immense in the types of actions, and it doesn't have, you could never have a violent crime and be subject to the mandatory minimum, like an actual person crime where someone is being hurt. And that, I think that is something that people do take into consideration when they're deciding whether or not they're agreeable, or, you know, whether or not you have a good argument for a departure. But I think that is part of the problem why you see a lot of departures, because there is that calculation taking place with certain types of offenses, or even like backgrounds of people who are getting subject to these mandatory minimums.
Thanks, Amber. Rob?
I think there have been a handful of comments where people have, members have brought up, what is the, thinking about what does the research say and whatnot. And I do think there is definitely some, Ashley had talked earlier about the like violence in the home, and that like violence that happens with people and that type of thing. And so there is mixed, my read of the research anyway is that the results are relatively mixed in terms of the ability of mandatory minimums to prevent future crime. My understanding of the research generally is that, for IPV types of crimes, they tend to be much more effective, but then kind of much less effective for other types of crimes. And so I think there's definitely something there, as well as, I think one of the things I brought up, I think that first meeting, thinking about, what is the motivation for mandatory minimums generally, if we're thinking of mandatory minimums as being, preventative or deterrent or something like that to prevent future crime, that's one thing. If we're thinking about mandatory minimums as being another thing, which like being retributive, being, hey, you did this thing that is wrong, so for the sake of justice, you need to go serve time or wherever that mandatory minimum is. That's another thing, right? And I think for that latter category, they tend to be, I don't think there's a lot of strong evidence that they tend to be very effective in that situation. So what I was just going to say is that I have been talking to, I have a graduate student who does a lot of work on sentencing and whatnot. And so I thought maybe it would be helpful. She and I could work together to develop just kind of a literature review on some of these questions, just kind of basis of, what is the research, at least what does the research today say about the effectiveness of mandatory minimums and kind of the various kind of gradations and nuances in terms of different sentencing schemes and different, offense types and whatnot, if that's helpful.
Thanks for that offer. So any other reflections before? Yeah.
My reflection on reading the New York thing was, they were talking in there, as I said, about sentencing guidelines. And I'm like, why are they talking about sentencing guidelines when they're talking about mandatory minimums? And sometimes, there's the question, does the fish know that it's wet? And I'm so used to living in a legal system where, there's the sentencing guidelines, which you can depart from if there's substantial and compelling reasons that can be articulated on the record. And then there's these mandatory minimums, which you can depart from if there's substantial and compelling reasons that can be articulated on the record. And I'm thinking, why do we have both of those? That's just a confusing system. And 6911 was born before 1978 when the Sentencing Guidelines Commission was established, and it just kept rolling on. And maybe it didn't need to roll on after that point. Maybe there are things that we could do, and maybe those things that the commission could do could be a little more refined and precise. The comment was brought up. I think Shane brought up the comment about, well, what does it matter what the prior? I'm thinking specifically here about the felon in possession 5-year mandatory minimum, one size fits all. It doesn't matter, what the prior record was. It doesn't matter how long it's been. It doesn't matter why the firearm's being used. It doesn't matter, whether you've got otherwise a clean record or you haven't had any felonies since in the last 10 years. So the sentencing guidelines can factor some of those things in. They can be a little more nuanced. They are designed to be tailored for the particular offense that's being committed. And maybe that should just be an enhancement. Like if you commit an offense and you commit an offense with a firearm that you're legally prohibited from possessing, then that's something that adds something to your sentence. But just saying 5 years might really understate the severity for some people. It might really overstate the severity for other people. But the sentencing guidelines, by adding it on top of the presumptive sentence that's already earned by the underlying misconduct, goes a lot farther toward tailoring it for a particular case. I think of crimes committed for the benefit of a gang. In some sense, that is a mandatory minimum where the legislature said this is always a prison case. But as far as the duration goes, it's really flexible, and it depends on the crime that's being committed for the benefit of the gang. How severe is that crime? And it also depends on the criminal history score of the person who's committing the crime for the benefit of the gang. Two things that you really miss out if the legislature just said, there's a 5-year mandatory minimum for everybody who commits a crime for the benefit of the gang, they would have lost a lot of what I would say justice there, because they would have missed out on what the guidelines factor in, which is, well, how much criminal history does this person have? How much, and what was the offense that was being committed? And those are, so I'm just wondering if, especially for non-mandatory mandatories, if we can't do something to move those over into the sentencing guidelines area, which really has the same standard, and I don't think you'd be losing a lot by moving it into the sentencing guidelines area.
Ashley, looks like.
Yeah, I just wanted to bring up something a little different. When I've been on these, working groups or task forces with folks from a variety of backgrounds, maybe a variety of different values that they're bringing, I guess I would find it helpful. And this is just a thought. I'm not married to it, but if we could create maybe some sort of a framework with which we're, assessing these things through, maybe if we could, and I know we're a diverse group for a reason, right? We're not all going to think the same way, I guess. But if there was some sort of like, you know, as we're analyzing this, we're trying to, you know, make decisions on, you know, like, and I think all this kind of comes back to some of the research questions too, like, are we making decisions because we want to, you know, reduce recidivism, we want to reduce racial disparities. I guess I'm just saying that I would maybe like a little bit of grounding in some of the ways that we're filtering this through. But I understand that everyone's brain operates in the way in that mine does. But I just wanted to kind of bring it up as a thing to consider as we're doing this work.
I mean, I think that's a really great point, and a really good observation. Absolutely. Yeah, Nate.
So just our charter statute includes the requirement to assess whether current laws and practices promote public safety and equity in sentencing. So that's kind of a starting point for us by law is do current practices promote public safety and equity in sentencing?
Yeah, I agree with that. I think the statute gives us a really great, sort of overview framework. And then, I think these last couple meetings, we've been collecting the membership. I think we're mostly full. We're going to review vacancies at the end here. And I was also just hearing the reflections that folks have been making really made me think that we made the right decision in forming these committees, because a lot of folks were talking about the need to collect and look at data on effectiveness, on number of departures, on what's happening in the state of Minnesota. A lot of folks were talking about understanding the legal framework that exists within Minnesota and like how it compares to other states. And then a lot of folks were talking about the importance of bringing in voices from community, from impacted groups like victims, like defendants. And so I think we really made the right decision when we created these committees. And, we did set some time aside in the agenda today for the committees to come together and have some sort of initial discussions. So with the consensus of the group, my proposal would be that we spend, I'd say maybe 20 minutes breaking out into the committees. Rob is the chair of the data committee, Mark is the chair of the legal analysis and purpose committee, and Kelly is the chair of the stakeholder input committee. If others agree, my proposal would be we go to that agenda item right now. We have a 20-minute breakout, which would bring us back at about 11:35, and then we could get through the rest of the agenda items. Does anybody object to that course of? Oh, that's a great question. Don, have we shared the committees?
I shared it with the two of you.
Okay.
I had not shared it with the group as a whole.
Okay.
I did put that together in a spreadsheet that I can share right now.
That would be great, Don. Thank you so much.
Yeah.
Yep. There are some folks that expressed interest in multiple committees, and that's absolutely fine. I think for today's purposes, pick one of the groups. And in terms of the expectation, for today, I'll really leave that up to the chairs and to the members of the committee. I think this could be sort of a continued discussion about some of these reflections that we talked about. I think it could be a discussion, to Ashley's point, about how to bring a framework or a structure to this. It could be a discussion of who's going to be doing some particular work, or maybe another time to meet. So.
One point, though, we do need to keep the committee membership on each committee below a quorum. Not just because to operate efficiently, a committee needs to be unshackled by the open meeting laws. Everything they talk about will eventually come into the meeting. So it's not like we're doing anything in secret, but need to be just able to pick up the phone and call their committee members without So we need to have it less than a quorum for each committee, which is 7 or 8.
Quorum is 7.
Okay.
And I do not have Nick on there. I didn't get you that, the link, so you can pick which one you'd like to be in and.
So I think for the people in the room, we'll have to use our laptops to join the WebEx. But otherwise, I think, Don, are you able to?
I can make breakout rooms for each of the committees, yes.
That would be great. So I think it'll take maybe a couple minutes to get that set up. And so I think we'll say we'll come back at 11:40. Does that work?
Sounds good.
Okay.
Sure. Oh, we're in the same committee. Okay.
So Morgan, we're not in the breakouts, right? Because you're not in my committee. So
Yeah, I know.
and obviously Rob has to get to his own committee.
Yeah, hey, Mark, I heard your question there. We were getting an echo. I'm having a hard time getting an invite into a breakout room as well. Did you get an invite on your system?
No, I mean, Morgan, it sounds like
Don, the folks
committees-
online are saying there's no, they didn't get invites. Maybe we. Oh, okay. No, thank you. Sorry about that confusion here. I don't use WebEx very often, so. Okay, so I think we're all coming back. We've only got 12 minutes left, but I think it would make sense if we just very briefly went to the chair of each committee and asked for just maybe a 1-minute summary of sort of what the discussion was and maybe what the plan is moving forward. Rob, if I can put you on the spot to give just a real quick summary of the discussion and the plan from the data committee.
Sure. So we talked about a lot of different things,
we can't
and
hear
I
you
think
for
one of
some
the
reason, Rob.
oh hello hello
Oh, we're muted.
I'm sorry.
We're sorry. We're turning the sound back on. All right, we're good.
okay. Yeah. So I think our plan will be to there were a lot of different questions that have come up over the previous meetings as well as this meeting and others, and I think people have additional questions. So one thing I'm going to do is have my graduate student go back through the old meetings as well as the notes and the memos and whatever, or the minutes, to kind of to catalog all of those questions. And then we also want to send a solicitation for additional questions for things that have not come up. And then we will compile all of those questions. And then I think what we'll go through and develop, what would be the sources and the ways that we could get at those questions, and then kind of categorize or prioritize which questions are most important. And then I'll propose a data analysis plan, including data sources and everything else, and kind of present it to the committee, kind of make sure everything seems like it's going well. And then if so, then we'll move forward.
Great. Thanks, Rob. Kelly, do you want to?
Yep. So what we talked about really was the next step for stakeholder input is to put out a mini solicitation for an entity that would conduct that work for us. So we really brainstormed what needs to be in that solicitation. So I'm going to write that up, and I'm wondering if it's possible if I get it. Do you guys want me to bring it back here? I don't think it should actually come back here.
I think you need
so
to.
we'll get it out. So I'm going to get it out. And then one of the issues I just want everyone to be really aware of that we do face is, having been a researcher myself, I do really believe in paying people for their time if they do an interview. We have a problem though, because DOC doesn't have authority to do that. So I'm going to try to work with the powers that be in the state to see if there's some way to, since this is not DOC doing the work, since this is really a different task force, I'm wondering, I'm going to ask the question whether we could get sort of special dispensation to be able to do that. Because I think that that's just it's a problem we've been dealing with at DOC also, and at other agencies within the state. So I just wanted to call it out and say that that's a hurdle that we have to figure out how to overcome.
Great, thank you. Professor Osler, do you want to talk about your committee?
Sure. We talked about what's been done so far. I think we kind of have to wait for the other committees to catch up a bit, especially data committee, where a lot of what we're going to be talking about will intersect with what they're doing. And we continue the discussion as well of what it would look like to fold mandatories that aren't mandatories into the guidelines, and the reasons, both practical and philosophical, for doing that.
Thanks. Okay, great. Next agenda item is review of vacancies. John, if I could put you on the spot.
Absolutely. We still have one spot open, and that is the one that's being appointed by the House of Representatives. I did get a point of contact, and I did give that point of contact to Nate to have him reach out to express our desire that we want that position filled. Because the impression that I've gotten is that they didn't feel it needed to be filled.
Okay.
So hopefully better news in December.
But so that otherwise we're full, just the one position.
Yes, just the one position.
Okay, great.
And I have a good working relationship with those people, so I'll send that out today.
Great, thanks, Nate. Any other, the last agenda item is just confirming the next meeting date of December 12th. Unless there's anything else, I think we've covered the agenda and we can adjourn for the day.
Thank you.
Yeah, thank you all. All right. Thanks, everybody. Have a good one.